Hello, and thank you for attending and listening in on our webinar. Over the next few minutes, this webinar will give you a brief introduction into environmental due diligence and some other considerations and environmental considerations. Marijuana has been legal here in Michigan for a while. Recreational marijuana was just voted in during our last election in November 2018. And is working its way through the process of licensing rules and all that goes with that. During this time, we have seen an uptick in companies buying real estate for both retail dispensaries as well as larger tracts of land for growing and production operations. We've been working with a number of cannabis companies, and we are seeing that not everyone is familiar with environmental due diligence, and not everyone realizes the potential significant environmental liability associated with starting their operations. Additionally, we are noting that Michigan's environmental regulators are trying to get up to speed, if you will, with respect to which environmental regulations apply to this relatively new and growing market. A quick little bit about me, just so you know that I've been here and I've done that. I've been working in the environmental arena for about 38 years. I've been providing environmental due diligence since 1989 when I first joined the Dragun Corporation. And I've also served as an expert witness on due diligence projects, specifically projects that have gone bad. And we'll talk about that a little bit throughout the webinar. From my perspective, there are a handful of firms, environmental firms out there getting due diligence process right. They, like us, understand the potential risks involved for their clients. The unfortunate reality is due diligence is dominated by a lot of low-cost providers. And much of the time, this is not necessarily a problem. But when it blows up, it can be very expensive and a time-consuming problem for your project or your business. So is environmental due diligence different for the cannabis industry? The answer is yes and no. What do I mean by that? Environmental due diligence, that is understanding and knowing what you are buying in that piece of land, is necessary in some form, regardless of why you are purchasing real property, albeit for the cannabis industry or for some other use. After all, you don't want to be held responsible for contamination on a property that you purchased, but had no responsibility in causing contamination that may be found there. But if you don't conduct due diligence properly, that is exactly what can happen. Additionally, most lenders will require adequate environmental due diligence prior to lending on a property. Environmental due diligence for a buyer it's really your insurance policy when it's done right to not being held responsible for existing contamination on a property. And issues brought forth in a Phase 1 ESA, when they are discovered, can be used to negotiate price, so it can be a tool for you. Further, understanding the history of the property can help you avoid construction issues and delays. I've seen many a construction project come to a screeching halt because underground storage tanks and buried drums and other contamination have been encountered that may have been picked up front if during a due diligence process. And depending on your age, as I mentioned, I've been doing this a while, you might remember Love Canal in New York State. Love Canal was kind of the poster child for Superfund back in 1980. In a nutshell, Love Canal involved a former drum burial area. It was kind of quote unquote closed with some engineering and administrative controls put in place. But fast forward many years and the property was purchased. It was developed with a subdivision without heed to those controls. And ultimately there was exposure to the buried waste. The development went very bad. and there was a long cleanup, and there were lawsuits. In an EPA journal back in '79, and this is a quote, said, quite simply, Love Canal is one of the most appalling environmental tragedies in American history. But that's not the most disturbing fact. What is worse is that it cannot be regarded as an isolated event. It could happen again, anywhere in this country, unless we move expeditiously to prevent it. And that's because there are, other situations that happened before some of the environmental regulations were out there, where people buried waste, people disposed of things without thought of what it might do in the future. And Love Canal was one of the main impetuses for CERCLA, the Comprehensive Environmental Response Compensation Liability Act, or more commonly referred to as Superfund. And out of Superfund and some of its amendments in 1986 and again in 2002 came the federal All Appropriate Inquiries rule. And the purpose of this rule is to provide liability protection with respect to environmental conditions that exist before you purchase a property. And since 1993, 13 years after CERCLA and some years even after the amendments that provided liability protection through the All Appropriate Inquiries, ASTM International has developed the standard, if you will, and the sort of checklist that is commonly used for Phase 1 ESAs. And while checklists are good, a checklist mentality is not good. This checklist is not a substitute for genuine due diligence efforts. Unfortunately, in my opinion, Phase 1s have become routine, and when not done as a serious undertaking, they can expose the buyer to serious liability. More on that later, but bottom line from my point of view is, I can't get the Phase 1 ESA wrong for my client or for me. So let's talk briefly about environmental due diligence. I'm still amazed at how many people think a Phase 1 ESA is unnecessary or simply a waste of time and money. I think it's because it's often not tangible. During the Phase 1, we are looking at a property's history to understand if there might be an environmental issue looming underground that often isn't visible. It's a lot easier for someone to understand and pay for a property survey, a roof inspection, a structural inspection, because they can see and touch those things. But a Phase 1 ESA, it's more like going to the doctor and asking him or her to tell you if you're sick. The doc is going to look at your vital signs, see if you look pale or have any obvious outward signs, review your medical records, ask you questions, and either provide a diagnosis or recommend additional tasks or tests. Phase 1 is very similar. It consists of 4 components: looking at records, conducting a site inspection, conducting interviews, and preparing a report or a diagnosis. The Phase 1 does not include sampling of soil or groundwater. It's strictly an information investigation. But ultimately, these pieces of the puzzle are pulled together to see what the picture looks like. In Phase 1 speak, does the picture reveal a recognized environmental condition, or is it typically referred to an REC? Where the doctor is looking for symptoms of illness to your body, we are looking for what are, again, defined as RECs. And while the REC has a definition under the law, it's a condition that comes out of our record search, our site investigation, and interviews that's indicative of real or potential release of chemicals to the property. These can include just the historic use of the property, such as a gasoline station, a dry cleaner, or industrial manufacturing, to name a few, or it can be something visual, such as significant staining of floors or the ground surface, indicating that historical chemical release has occurred. And just like the doctor who may recommend blood tests or other tests to better understand the magnitude of an illness, we sometimes need to conduct a phase 2 to put that REC in perspective. You know, and the phase 2 usually involves collecting soil or groundwater vapor samples and testing them for chemicals that would be associated with the historic use of the property that you've uncovered. And so let's talk just a bit about the phase 1 process. As mentioned, there are 4 main components, but interviews and site records are often the initial steps in the phase 1 process. And it's asking the most basic questions of who, what, when, where, and how. Who was owned or operated on the site and during what time periods? What were they doing at the site? Where were they doing it and how did they do it? All of these can begin to focus your understanding of the site history, and through that help focus your site inspection and in determining whether a rec might exist. So when we're looking at records, what do we look at? Well, to be honest, as much as we can, given the time and the cost restraints of the project. But typically we're looking at historical maps, historical fire insurance maps, historical USGS topographic maps, aerial photographs and chronologic aerial photographs that can provide this chronologic pictorial history of the development of the property. We also look at regulatory files that can give us an insight to chemical and waste handling that was conducted at the property, as well as permitted discharges that the operations may have had to air and water. We look at city address directories. We look at water well logs, fire department records, and other municipal records. And again, all of these help us to piece together whether the property may have a legacy contamination that needs to be evaluated prior to purchase of the property. Additionally, we try to interview people that are familiar with the property. Interviews are a great way to fill information gaps. It's typically easy to understand the current condition and operations of the site during your site inspection and interviewing a current facility manager. The hard part sometimes is looking further in the history, but also some of your best sources of information is when you can sit down with that guy that has been there kind of forever. The guy that likes to tell the stories that start with, well, before we had that waste storage area, or the one that knows what they used to do with their waste before they were doing it the right way. Also when you're out at local offices, try to find that old guy, that old sanitarian at the local offices. They can usually tell you stories about the property before it was developed as you currently see it, or stories that start with when so-and-so used to operate there, we were always getting odor complaints all the time. We use all that information to again, pull together, and after all, we're trying to make sure that you're not buying an environmental nightmare. You're not buying your own little love canal. So the more stories we can look into, and the more stones we can turn over, the more confident we are in our conclusions, and hopefully the more comfortable you are in understanding what you're buying. The site inspection is really your opportunity, or our opportunity, to get a snapshot of the current condition of the property. And we're looking for very telltale visual indications that the property has been used in a manner that may have resulted in contamination. What are we looking for? I use these couple of pictures to make a couple of points. The photo on the right shows that things are not always what they seem. It's just a house, or is it? As you can see, this house had a rather large underground storage tank buried. The UST was formerly used to store fuel oil. And note that the fuel oil had not been used at this house for over 40 years, and the current owner didn't even know it was there. Some of the telltale signs that we saw included some remnants of piping holes in the basement wall. And ultimately, we found what you see sitting outside of that house. The photo on the left, on the other hand, shows a concrete patch in some asphalt. And this is a telltale sign that at least raises our eyebrow a little, that there was a former UST here. The UST was removed, and when they had pulled the tank out, they patched it with concrete, which is different than the asphalt. You can see vice versa, where you'll see asphalt patches in concrete. We ended up here having to do some phase 2 work to sample and see if there was residual contamination from the underground storage tank, the fuels that were in it. And in this particular case, there was some residual, but not too much, such that the buyer walked from the deal. The phase 1 ESA wasn't clean, quote unquote clean, but following the phase 2, the wreck was shown to be clean enough, if you will, and the deal went through, albeit with some negotiation of terms. And similar to a doctor's diagnosis, the phase 1 ESA report pulls all the information gathered in the site inspection, the information gathering, and puts it into a perspective relative to the all appropriate inquiries rule that we talked about earlier. The report should conclude whether there are or are not RECs associated with the property. And as I talked about before, not all our RECs are created equal, and ultimately it's a business decision as to whether to act on an REC when it is found. Also, as discussed earlier, a clean phase 1 ESA might not be as clean as you thought, so kind of be careful. I should probably step back for a minute and talk a little bit about when you engage a consultant to conduct a phase 1 ESA. Whenever I take a call regarding a phase 1 ESA, one of my first questions is whether legal counsel is involved. I truly believe that the due diligence process is like a three-legged stool. It has a business component, you, has a legal component, your attorney, and it has a technical consultant component, someone like me. And each of these plays a role in garnering your best defense to liability under CERCLA. And all of these need to weigh in on the process. And quite often we're retained by legal counsel rather than the actual buyer. I'm not saying it's absolutely necessary, but I do tend to advise my clients to talk with their attorney before they jump into a deal. And through my many years of doing this, I can't tell you how many draft reports I've discussed with legal counsel prior to finalizing a report. When the phase 1 does identify a wreck, that wreck needs to be put into perspective. It needs to be put into a perspective both from a regulatory perspective of CERCLA and your liability protection, as well as a business perspective about where you're trying to go. What are the goals of this property for your business? And as I mentioned, not all wrecks are equal. In some instances, the perspective on the wreck can be accomplished simply with additional paper review. There are times when additional reports or data can be researched and found that may put a wreck into sufficient perspective, and phase 2 sampling isn't necessary. But often a phase 2 is conducted, and the phase 2 typically involves using geophysics to look underground and or collecting soil samples or groundwater samples or vapor samples to determine the magnitude of the contamination. I've done phase 2 ESAs that involve simple hand augers, all the way to the other end of the spectrum involving drill rigs, soil samples, groundwater samples, subslab vapor samples, the full gamut. It really all depends upon the specific situation, the type of property, and the rec and the business goals associated with that project. The degree to which a rec is investigated may include how it might relate to your business and your business goals. In the cannabis world, if you're purchasing property for growing operations, you may want to know certain things about the soil quality different than if you were buying it for a retail space. The scope of the phase 2 might be developed with a different or an expanded focus, again, depending on your business goals. And what you see in this slide here is a picture of a geoprobe rig that's a common tool that we use to go out and collect soil samples and groundwater samples at a site. If the phase 2 finds contamination, it doesn't necessarily mean that you shouldn't buy the property. The due diligence process, both on the federal level under CERCLA and on the state level here in Michigan under Part 201, is set up to provide certain liability protections relative to your cleanup obligations. That said, determining the level of contamination and what the contaminants are is very important. Both the federal and state due diligence regulations have what are called continuing obligations or due care obligations. And what that means is, although you're not responsible for cleanup because it was there before you bought the property, you still have obligations to make sure that there are not undue exposures to the residual contamination on the property, and that your activities on the property moving forward aren't going to worsen that contamination. So understanding this is really important to your business decision. And again, I recommend involving legal counsel in that process. Beyond the due diligence component of buying the property, so you go through and do your environmental due diligence so you can understand what you've purchased and is it contaminated, is it not, do I have any of these due care obligations. There are other things that you should think about from the cannabis perspective. In addition to just the permitting that you need to go through to be able to grow and sell cannabis in Michigan, the Department of Environmental Quality has other environmental considerations relative to growing and processing of marijuana. And while they apply to other types of businesses and operations, the department has pulled these specifically out of concern of theirs. So when you're developing a property, keep these in mind for cannabis, keep these in mind as you move forward. And the things that they're really focused on are, they include where you get and how much water you're going to use for your operations. Are you going to be using groundwater, and how much groundwater? And you may have to look into that more deeply than just putting in a well and starting to pump. And some of your growing operations may be outside of where you can access municipal water. They're also looking at how you handle your stormwater and your wastewaters. If you don't have a municipal system to discharge your wastewater to, there may be other significant considerations of how you handle that wastewater, and also how you handle other wastes that you may generate. You may be applying pesticides and herbicides. These are things you want to consider when looking at your property, and where the location of your property is. While it may seem like the perfect location, based on the community and licensing, if you can't get enough water, it doesn't matter. Additionally, if you have a problem with wastewater disposal and need to haul it off site, the cost may become prohibitive for what looked to be a perfect location for your cannabis operations. We've talked about a lot of things in a relatively short period of time. And I'd like to leave you with just a few takeaways from this webinar. You know, it's often said that your most expensive attorney might be the cheapest attorney. And think about that for a minute. But I believe that's also true in the consultant world. You know, find someone out there that you trust, build that relationship, and let them do their job to help protect you and your investment. You know, this due diligence is your insurance policy, so beware of commodity services. And keep in mind, it takes some time to do it right. And if there's kind of one constant in environmental regulation, it's that it constantly is in a state of flux. We send out some monthly environmental newsletters to keep our clients kind of up to speed and on what's changing and what some of the requirements are. So if you'd like to sign up for our environmental newsletter, you can do so at our website, www.dragun.com. And I hope this has been, this information has been helpful to you, and thank you very much for listening.